The late District Attorney Richard Brown's legacy is one of a hard-charging, tough-on-crime prosecutor. Queens right now is the most punitive borough. The District Attorney's Office sends more offenders to jail for misdemeanor cases than any other District Attorney in New York City. Would you continue that stance or change it? If so, how?
So I firmly believe that we need to stop criminalizing the three root causes of crime, which are usually poverty, people with mental health issues, and people with substance use disorder. And as a 21st century reform-minded modern-day prosecutor, I think what we need to be doing is treating the root causes of those instances. And so treating it with services, treating it with the types of treatment that people with mental health issues or substance use disorder need, and not criminalizing people on low-level offenses that do nothing but give them criminal convictions and saddle them with a criminal conviction that gives them collateral consequences, which affects them for the rest of their lives. Their ability to get a job, their ability to get housing, their ability to get a loan, sometimes even an education, and their ability to get a license.
So are you saying that you wouldn't prosecute misdemeanor cases? Or you wouldn't send them to jail? How would you handle it?
I think incarceration should be the exception and not the rule. And we should be looking at diverting cases where we can divert cases. We should be looking to decriminalize marijuana, low-level marijuana possession offenses, which is what I did with Brooklyn DA Ken Thompson as his special counsel in Brooklyn. And we should be looking to decriminalize other types of low-level offenses that do nothing to impact public safety in a positive way.
So would you prosecute them, or you civilly, or what would you do?
Well, for example, fare evasion. Fare evasion you can give a summons for, as opposed to arresting somebody, putting them through central booking, putting them through the arraignments process, which costs about $2,000, right, to get that portion of the process done. Why are we doing that for a $2.75 fare? We should just be issuing civil summonses for those types of offenses. For example, if you don't get a ticket for your windshield when you park your car on the street, they don't come and arrest you. If you drive through a toll and don't pay the toll, they're not coming to arrest you. You get a ticket in the mail. So something similar along those lines, so we're not clogging up the criminal justice system and our jails with people who just don't pay a fare.
So that was sort of my second question. What's your position on prosecution of so-called broken windows offenses, like public urination or turnstile jumping, for instance?
Again, I don't think that we should be putting people through the criminal justice system. If you look at the economics of it alone, it doesn't make sense for someone to go through the criminal justice system, which costs about $2,000 for a $2.75 fare. Certainly people should be held accountable for their actions, but we can do it in other ways where we're not incarcerating them and we're not putting them through the arrest, booking, and arraignment process.
Okay. Next question. The use of recreational marijuana is still against the law in New York State. Are there any marijuana prosecutions that you would undertake?
I think that it's important that we decriminalize marijuana, particularly low-level marijuana possession offenses, but certainly if there is sale and distribution of marijuana going on, possession with the intent to distribute, we should be prosecuting those types of cases, particularly if they're on a large scale.
What about the sale of marijuana near a school or sale to minors?
Certainly a sale of marijuana to minors is not in the interest of public safety. And so we would be looking to prosecute those cases, but again, making sure that the prosecution is fair to the person. And where we can divert cases so that we're not clogging up the criminal justice system and not incarcerating people on low-level offenses, we should be doing that. But I am not in favor of selling marijuana to children, to minors, or in the vicinity of schools.
But so would you prosecute them civilly? Would you do it criminally, even if it was like a small amount, like a nickel bag or something like that?
Yeah, it would depend on the case. I would look at it on a case-by-case basis, consider the criminal history of the person as well, but I'm not an advocate for selling marijuana to minors or in the vicinity of schools, and that should not be happening, and certainly we will hold people accountable. I don't think it's a civil summons in that sense when you're selling drugs to minors.
Okay. Next question. The new bail statute does not allow someone to be held pre-trial for misdemeanor assault, even though this is frequently the initial charge in a domestic violence case. Did you support this change in the law, and how do you think it will affect domestic violence prosecutions?
For domestic violence cases, because it's such a volatile situation, we need to be very careful with domestic violence situations. But there are certain parameters and certain things that we can put in place if someone is going to be released when there's an assault that occurs in a domestic violence situation. So for example, an order of protection could be put in place in a domestic violence situation. Certainly putting conditions of release so that the person who's charged with the crime can check in on a daily basis, on a weekly basis with somebody who can keep tabs on them to make sure that they're staying out of trouble, that they're doing what they're supposed to be doing.
So you would still allow someone to get out pre-trial for a misdemeanor assault?
If that's what the new law calls for on January 1st, 2020, I think as district attorney, I have to follow the new law.
Would you challenge the law?
It would depend on what types of circumstances and cases came up. If someone is...
I mean, did you support the law when it was being considered?
I support ending cash bail, certainly. I definitely support ending cash bail.
Even in cases of misdemeanor assault in a domestic violence case?
Well, I think that there are other ways to hold somebody accountable. The whole point of bail is to ensure a person's return to court. So in order to ensure a person's return to court, what are the parameters that we put on that person to make sure that they're coming back to court? It's not supposed to be punitive, and it's not supposed to be a poor man's tax, but it is just to ensure that a person returns to court.
So should sex workers be prosecuted, and what about people who own the buildings where this is happening?
My position and stance on that, in fact, I just issued a survivor's justice policy on that. I do not agree with prosecuting people involved in the life of prostitution or sex workers, but I do believe in prosecuting pimps and johns and sex traffickers. I think that we need to keep our county safe, and we have to stop the exploitation of our young people, particularly young women. I was the first person to indict someone under the 2007 sex trafficking law, and he started off as a pimp. He exploited two young girls after winning their trust, two 16-year-old girls, and then a 17-year-old young woman. And he won them over, exploited them, started taking the proceeds from them, and he pimped them out. But after a while, when they wanted to get away from him and out of the life, it got violent. And so we need to protect our communities from that.
So what about the people who own the buildings where this is going on?
Well, if they are brothel owners, they should definitely be prosecuted because they're adding to the exploitation of women, exploitation of our youth, exploitation of our young men sometimes. So if you're talking about landlords who are really brothel owners, we should be prosecuting them as well. If they are landlords who do not know what is going on in the places that they're renting out, I think that's a different consideration, and we should be looking at it on a case-by-case basis. Because certainly we want to hold people accountable for their misconduct and their misdeeds, but we have to make sure we're holding the right people accountable.
Okay, so next question. Since Richard Brown was such a tough prosecutor, should there be a review of all sentences of people over age 30, and would you recommend reductions? And if so, for what crimes?
Well, if you're talking about a sentencing review process, then if it's something that justice demands, I would certainly consider it. But looking back at old cases, you want to make sure that there's continuity throughout all the cases and that you're not creating a disparity going forward. So that's something that I would take into consideration and look at down the road. But my first priority in going to the office is making sure we establish a conviction review unit, making sure that we establish a robust immigrant affairs unit, establishing a civil rights and integrity bureau, and making sure that we are dealing with hate crimes. Those are some of my initial priorities.
So if you did recommend reductions, are there specific kinds of crime you would look at?
It really would depend on the case and the scenario.
So discovery laws were recently changed. What's your position on the requirement that witnesses to crimes have their identities provided to defendants before the trial? And what steps would you take to protect witnesses from pretrial intimidation?
If there are no concerns about the protection of witnesses, witness intimidation, witness safety for either the victim or the witness, for example, if they're known to each other, then I don't see an issue with providing that information. But if there is a legitimate concern about witness safety, witness intimidation for either the victim of or the witnesses, we should be looking to protect them, because we need them to come forward, and we need them not to be scared to come forward when there is a criminal issue or a criminal incident that occurs.
How do you protect them?
You would seek a protective order from the court. In fact, I practiced in a jurisdiction, Washington, D.C., where we had open file discovery, and we would seek protective orders to protect the witnesses' names and their contact information to make sure that they were kept safe, particularly in violent cases.
So you would try to delete personal information? I mean, how would you do it?
That's right. Withhold the contact information of the witnesses if there is an issue with respect to public safety or with respect to the witnesses' safety.
So would you actively investigate cases of tenant harassment?
Yes, we would actively investigate cases of tenant harassment, assuming that we have the jurisdiction to do so. So if there is something in the penal law where a tenant is being harassed by an unscrupulous landlord, we should be looking into those cases, assuming we have the jurisdiction to do so, and holding those unscrupulous landlords accountable for their actions.
How big a problem is that in Queens?
Well, you know, on the campaign trail, Marsha, I've heard a lot of different stories about unscrupulous landlords and how tenants are afraid to come forward. They're afraid to come forward sometimes because of their immigrant status here in the Queens community. They're afraid to come forward because they fear retaliation from their landlords. And so as district attorney, I would make sure that tenants understand, regardless of their immigration status, or a victim in any crime, regardless of their immigration status, that they're able to come forward to report a crime and have discourse with the district attorney's office and be able to report the crimes that are happening out in the community.
So do you think that people have come to you on the campaign trail to talk about it because of the gentrification that's going on in the borough?
I think people have come to talk about it because it has existed for a long time. I don't think this is a new scenario. I think that sometimes when you have immigrant communities, and sometimes depending on their status or depending on how new they are to the country, they're afraid to come forward. They don't want to cause any waves, they don't want to cause any issues for themselves or for their family, and so they're afraid of law enforcement, they're afraid of reporting crimes. And that's something that the citizens of Queens County, all citizens, need to know, that the doors of the district attorney are open to everyone.
So how would you handle requests from ICE?
In terms of what?
If they came to you and they wanted to get, information about somebody who's either a witness, a defendant, anybody in the case you have.
My thought on that is that the courthouse should be a safe haven for everyone. Not only victims, not only witnesses, but even people who are charged with crimes, who are just coming to the courthouse to answer to the crimes for which they were charged. And the whole reasoning behind that is because we need to make sure that people feel comfortable participating in the criminal justice process. And by that, I mean that they need to be able to come forward and talk to law enforcement without fear of retribution, without fear of retaliation. And so I would be protective of them and make sure that the courthouse and the district attorney's office is a safe haven for them. If you don't, it impacts public safety, because there will be a chilling effect on people reporting crimes. And I've had numerous sexual assault victims when I was a special victims prosecutor. They didn't want to participate in the criminal justice process. They didn't want to testify at trial. They didn't want to testify in the grand jury because they were afraid that they would undergo retaliation or some sort of retribution, or their families would be torn apart.
So you say even in cases like, say, MS-13, you wouldn't let ICE anywhere near it?
Well, it would depend on the circumstance. If the person is convicted of a crime in Queens County and ICE is looking for them, and they've been convicted, if an MS-13 gang member is convicted of an assault, then certainly, and it's a deportable offense, certainly I think that ICE would have every right to come in and know everything about the case.
So you would make that exception for like somebody, a tough gang member who might be involved in a murder or an assault of some kind?
Yeah, I think that it's important that people are not judged before they're actually convicted. And so, you know, everybody has their right to their day in court. Everybody has the right to due process. And so we need to make sure that the people who are being detained and deported by ICE should really be detained and deported.
So this would be after trial, after conviction?
Yes.
Okay, should Rikers Island be closed?
Rikers Island is an abomination. It's an absolute abomination. It is unfit for human beings. And I think that I would not want any of my family member to be there, nor would I want any member of your family to be there. And so I do think that it needs to be closed down.
What do you do instead?
Well, there's some talk about community-based, borough-based jails or detention centers. And there's a lot of talk about that. I've been asked that numerous times on the campaign trail. And really, the borough-based jails or detention centers should be designed in such a way that they promote reentry and reintegration of the people who need to be detained into society. And right now we don't have that with Rikers Island. So the whole idea behind having a modern day facility is to make sure people are getting the services they need, the treatment that they need, they're in close communication with their legal counsel, and they're in close proximity to their friends and their family and their support networks. And that, the idea behind that is that they will recidivate less because they're more connected to their communities, and when they go back into the community, they will be a better person for doing so.
But the thing is that the community jails, there's only plans to build them in 4 out of the 5 boroughs. Is that fair that Staten Island doesn't have a community jail?
No, certainly if we are moving towards community jails, they should all have a community-based detention facility. But what's also important is that there has to be community input. So there has to be community input, and I think that's been a problem and an issue in past circumstances where the community feels they're not being heard. They should have a say in how big the facility will be, the design of the facility, and where the facility will be located.
Well, presently they want to locate it across from Borough Hall on Queens Boulevard in Kew Gardens. Your feelings?
There was a community-based detention facility in Kew Gardens a long time ago. And the cost of...
Yeah, but it wasn't, you know, multi-story high-rise building the way they're proposing now.
No, and it shouldn't be going forward either. I think it would defray the cost of the traveling cost of $42 million a year that the city pays to transport people who are detained to the various courthouses from Rikers Island. I think it would defray those costs. But I also think that having a community-based jail will keep people who are detained closer to the courthouses so that they don't have to wake up at 4 o'clock in the morning and take a bus, go through security measures, and be at the courthouse at 10 a.m. or sometimes be shipped to another location, such as the Bronx.
But so the one thing about the Queens jail is that it would also house female suspects, and those would be from all 5 boroughs. So doesn't that defeat the purpose of having a community jail when the women will be treated differently in that they'll still have to come to, everybody from 5 boroughs would have to come to Queens instead of Rikers Island to see their loved ones?
That's definitely a valid point, because if the whole idea of a borough-based facility is to keep people closer to their support networks and their legal counsel, then you can't then turn around and have all the women housed in Queens, because how is legal counsel or family and support networks from the Bronx supposed to travel to Queens to see their loved ones? So I definitely think that's a valid point and needs to be addressed.